All have business before this court, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. We're beginning this morning with Elizabeth Ann O'Brien against Cynthia McMahon as trustee and others. Are you ready to proceed?
I'm ready to proceed.
All right. You want to save some time for rebuttal?
I do, Your Honor. If it pleases the court, I'd like to reserve 3 minutes.
All right.
May it please the court, my name is Philip Howell. I'm here for the appellant Elizabeth Ann O'Brien. This case arises from a declaratory judgment action that we filed on behalf of our client Elizabeth O'Brien, alleging her entitlement to 50% of the proceeds of a life insurance policy issued by a Prudential insurance company. And also the appellees had a competing claim. In fact, in the lower court, there were competing motions for summary judgment that Judge Terrell ruled upon. There's no dispute in this case that in 1996, Elizabeth...
So you judgment would be a way to dispose of the case.
We did, Your Honor.
Changed your mind about that?
We haven't, but we would allege that there are different facts that would allow Elizabeth Ann O'Brien to succeed on summary judgment as opposed to allowing the appellee to succeed on summary judgment.
Now, what different facts are you talking about?
Well, in this case, Judge Terrell in the lower court, we believe that he did not apply the strict compliance doctrine appropriately.
That sounds like a legal point.
Well, that is a legal point. But there were questions of fact that he decided upon to allow the other side to win, and those facts would include that Judge Terrell just considered, he didn't make clear his findings of fact, but he considered that Prudential received the form, a change of request form, and made it a part of the policy. There was disputed evidence on that particular point.
About whether they received the form? There was a dispute about that material?
Whether it was made a part of the policy.
What do you mean by that?
Well, the policy requires a few things for a beneficiary change request to be effective. Although it gave Mr. Todd, who was the policyholder decedent, the ability to change his beneficiary, that was limited by a few things, including that the change request had to be in writing, and also that it had...
Is there a dispute about whether it was in writing?
No, sir. There's no dispute. But also whether it met the needs of Prudential, and that's the entire dispute. And that's why this is a legal issue. We believe that Judge Terrell misapplied the strict compliance because he did not properly consider terms in the policy that would require the change form to meet the needs of Prudential.
A legal issue, but not necessarily a factual issue at this point.
Not on our side, Your Honor. We believe that the facts are crystallized and undisputed that would allow us to succeed, the appellant to succeed, but not the opposing party to succeed. But our primary point here today is that Judge Terrell did not apply the strict compliance standard appropriately to the undisputed facts in this case.
All right, let's hear about that.
Well, Judge, there's no dispute here that the strict compliance standard is the standard that this court is being asked to apply and that we asked Judge Terrell to apply. Both parties in their briefs, they both agree on that point. But I think it's important to look at the facts of the case just a bit. It's important to note that the lower court only looked at the 1999 change request form that was submitted by Mr. Todd. It's not only income, and because of that, Prudential responded to Mr. Todd and told him it could not process his request, and it asked for more information so that the form could meet his needs.
Now, isn't it actually the case that they told him in response to the request that came the following year that they could not process it? But I don't believe they ever said that in response to the 99 request, did they? Yes, sir.
In November of 1999, the record will reflect, and we've attached this as an exhibit to our motion for summary judgment, which I believe is tab 39 in the record. But a November 1999 response by Prudential says that we are unable to process your request. We need additional information. The language changed slightly in the Prudential letters after the 2000 request, where they said we're unable to process your request at this time.
But counsel, isn't it the fact that Prudential's records reflected that they in fact changed the beneficiaries themselves after that date in their computer records, while they may not have changed the guardians?
No, that's not true, Judge Rowe. What actually happened is, even at the time of the death of Mr. Todd, Prudential still believed and took the position initially in this litigation that the correct beneficiary was Elizabeth O'Brien and Madison Todd, as opposed to Heather Todd in place of Elizabeth O'Brien. I think the only thing that's in the record was an email or emails inside of Prudential where they talked about who was the appropriate beneficiary. The record reflects that those emails were between folks who really weren't brought up to speed on this issue, but the change had never been made to the policy. And that's why Prudential continually, over a period of about a year or more, wrote to Mr. Todd telling him that they needed more information to process this request. It's important to point out that Mr. Todd was familiar with this procedure because when my client became a beneficiary of one half of the policy in 1996, Mr. Todd submitted on virtually the same form identical information except for the names of what he called guardians of the property, which we've later determined must have meant trustees, and the children that were to be the ultimate beneficiaries. Prudential responded in the same way, telling him that they couldn't process his request and needed more information. But in all of these instances, what Prudential did was they didn't just tell Mr. Todd that they couldn't help him. They sent back a form which they believed met their needs. And here are some of the problems with the information supplied by Mr. Todd in all of these requests. He repeatedly referred to adults as guardians of the property and that they were to be the beneficiaries and hold this property for the children. He didn't put that information in the trustee provision that was provided for him in the form that was provided by Prudential. And certainly Prudential has no way to designate a guardian of the property. That was just one of the problems. In other change forms, like in 2000, he had inconsistent settlement modes. He also never identified the relationship of the guardian/trustee to himself. And all of those are facts and information that Prudential requires on its form, and that's information that it needs to properly maintain these very significant insurance policies. And so when it asked him for that information in 96, and they sent him a new form which changed guardian to trustee, asked him to tell the relationship between him and this trustee, and how long the trustee would be responsible for the money, because Prudential would only allow the trustee to be responsible until the age of 21 for the ultimate beneficiary. When they filled out the form for him in 96, he signed it and sent it back. Had he done that in 1999 when that form was sent to him by Prudential, none of us would be here today because the appellees would have exactly what they wanted. Why Mr. Todd didn't do that, we'll never know. But in Florida, that's not the question. In Florida, the question is strict compliance. We're not asked to look to his intent. And it appears that...
So in your view, is his intent immaterial?
His intent in Florida is immaterial. Now, there have been some cases that have been cited by the appellees which seem to indicate that if an insured policyholder does everything that he could do and everything that he knew that he could do, that there may be a narrow exception, although it's not always phrased in the case law as a narrow exception to strict compliance, but essentially that appears to be what it is. In this case, we have none of those facts that cry out for any equity or any exception to the strict compliance rule. And the reason is, Mr. Todd had been through this before. He had gotten exactly what he wanted before. And then in this case, he could have gotten exactly what he wanted.
You don't think the facts that, I mean, the rather dramatic facts here that under the 96 change, a niece and an adopted daughter receive the benefits of the $10 million policy. Under the 99 change, the niece is left with no benefits, and two adopted daughters he designates as beneficiaries. Incompletely in your argument, and I appreciate that. But you don't think those types of facts fit under the exceptions that the other cases talk about where you look at the intent?
I don't, because the testimony in this case indicated that the relationship between niece and uncle was extraordinarily close and always had been long before the daughters were adopted. And in addition, Mr. Todd made arrangements for this one daughter, who's the ultimate beneficiary if the appellees win, to receive the bulk of an estate valued in the tens of millions of dollars. And so was Mr. Todd Was he planning all of this so that both daughters and the niece were all taken care of? Could be. We don't know. But in Florida, those are not the sorts of questions that fit into the narrow exception that these cases cited by the appellees indicate. In one of those cases, two of the cases that are cited by appellees, the Smith v. Wilson case, 440 Southern 2nd, 442, Florida, First District Court of Appeal from 1983. It was a city employee insured under a group life insurance policy. He filled out the form that was provided for the change, and he gave that to his employer, who was essentially the agent for the carrier. Those are completely different facts from what we have here. And in the Travelers Insurance Company versus Davis case, 102 F. Sup. 5 from the Southern District of Florida from 1952, the employee completed the proper form, which apparently included all the correct information. He mailed it and then died before it actually reached the carrier. Those are completely different facts.
Tell us how you see the first case as essentially different. I see your point on the second.
Well, in the first case, the employee completed the form and actually handed it to an agent of the carrier, because the court did use the language agent. And in that case, there's no indication that the form contained incomplete or incorrect information, or that policy had the provision that allowed Prudential to request information that met its needs. That's a very significant part of this insurance policy. Mr. Todd had the opportunity to change his beneficiary if those two conditions were met. The second condition was never met. Prudential never had the information that it needed in a form that it needed to keep these beneficiaries perfectly straight. Is
it clear from the record that there was no guardian of the property?
Well, there was never a guardian of the property that we're aware of, Your Honor, and Prudential understood this to be an unsophisticated request for a trustee. But to make that clear, they have to have Mr. Todd sign off on that. Certainly, if his intent was to have the McCrearys always hold this property for these children with no age limit on that. First of all, that's not what the lower court gave in this case. The lower court did not give the property to the McCrearys, who were designated as guardians of the property, for the life of the McCrearys or for some other period of time. What Prudential needed to know, and what they didn't know, was, do you mean trustee? Do you want this duty to stop when the children reach some age like 21? And what is your relationship to the McCrearys?
You're into your rebuttal time.
Thank you, Your Honor.
May it please the Court, I'm Ted Borowski with Borowski and Duncan, and we represent Robert and Tanya Hurst, the guardians for Heather Todd Hurst today. I'm going to endeavor to reserve some of my time for Mr. Beasley for his portion of the appeal, should it work out in that manner.
All right, now, the McCrearys were never guardians of anybody's property, right?
That is correct. That is correct. But that designation in the October 18, 1999 change of beneficiary form did not confuse Prudential. Prudential is not arguing that was an issue. The trial court found that the designation in October of 1999 did in fact designate Madison and Todd, the first adopted daughter of Calvin Todd and Heather Ashley Todd, as the beneficiaries.
All right, but if he names as beneficiaries some people who are as guardians who are not guardians, that's a reasonable thing for the insurance company to say, well, what are you talking about?
But the communication after October of 1999, after the beneficiary form, was in fact received by Prudential. All of the communication from that time, including up to the date of Mr. Todd's death, addressed the issue of how we're going to pay these proceeds. There is not one communication for Prudential that indicates that Prudential had a difficulty or a problem with the designation of Madison Todd and Heather Todd as the beneficiaries.
What about their initial response, asking him to sign the form that they had prepared for him?
The initial response came back with provisions in the one of the difficulties is that the form that Prudential uses for this is a multi-purpose form. It includes beneficiary changes, ownership changes, changes in the settlement options, which in fact there are multiple settlement options that are permissible under the policy. And in fact, even the beneficiary post-death can change or elect a settlement option. Mr. Todd's communications with Prudential after October of 99, including the November forward, all pertain to how he wanted the proceeds of the insurance policy paid to these two children. And even in the March 2000 communication, the communication from Prudential, I would submit, presumed or assumes that the McCreary's were in fact the person through whom these proceeds would go through, as if the October designation of Heather and Madison was in fact effective. I think Judge Rowe was correct. I'm sorry, sir.
I didn't mean to interrupt.
I was going to say, counsel, did the terms of the policy require Mr. Todd to even designate a trustee or guardian, or could he simply have just changed the beneficiary?
He could simply change the beneficiary. The policy is very clear in the provision on beneficiary change that Mr. Todd had the right to designate a beneficiary or change the beneficiary. The appellant seeks to claim strict compliance, but what the appellant is really seeking to do is add additional requirements. That provision requires that the change be in writing and be in a form that meets Prudential's needs. What the appellant wants this court to do and ask the trial court to do, which it refused, is include in this meeting Prudential's needs a number of content approvals. Throughout the brief, you see that the appellant wants the Prudential to have the right to accept or apply this to the policy or take some other steps within its procedure. And of course, the testimony of the Prudential employees is this is how we process these requests. The appellant wants that to all be included within the requirement of the policy, but that is not what the policy says.
But what is the answer to his question? Why didn't he sign the form and send it back?
I don't know that we will know the answer to why Mr. Todd didn't. From looking at the forms, it's because he did not want the payout in the manner in which the settlement options in the policy provided. And there are 3 or 4 options. However, Prudential can agree to a settlement option or a process or procedure of paying out the funds other than is in the policy, but that would in fact require Prudential to agree. That's a wholly separate issue, and the trial court found, and I believe properly so, that the issue of the settlement mode or settlement options, the payout of these proceeds, is irrelevant to the question of did he in fact change the beneficiaries to his 2 daughters rather than his daughter and his niece.
All right, so you think that they are stretching this in a form that meets our needs language beyond its intended purpose?
Absolutely. And in fact, the decisions that they cite in support of that in a form means on a form, first of all, that's not an argument that I have made or intend to make. In does not mean on. My argument is that because Prudential provided the form, then the change of beneficiary is in a form that meets their needs. My argument is not that in a form means on a form. The Trustee decision, for example, which is the only one that has somewhat addressed that language, doesn't actually help the appellant, because in the Trustee decision, the holding was that Prudential could in fact require that it be on their form an original, what I'll call a blue ink signature, provided by U.S. mail. Not that Prudential had the right to pass upon the content or whether the change in that. The Trustee decision is a very complicated decision involving really investment trading through a variable annuity policy. And there's a tremendous amount of facts that have nothing to do with what I'll call a more simple life insurance designation. But at the end of the day, the Trustee decision said, and it's a district court decision out of Pennsylvania, trial court decision, at the end of the day, it said that Prudential had the right to require the particular form or to designate the procedure for sending the transfer request in that case. That's not the issue. There is no dispute here that Mr. Todd prepared the form or signed the October 18, 1999 form, sent it to Prudential, and that Prudential received it in the home office. That's all that the language of the policy requires. That's strict compliance with the policy. And anything further than that is where they're trying to include in meets our needs some approval process that requires all the things that Prudential might want to do with it afterwards.
Well, aren't they saying there is no guardian of the property? We don't want to be involved in litigation. we'll work with you if you want to name them trustees, which you can do without court involvement.
The communication back all recognizes that Madison Ann Todd and Heather Ashley Todd are the beneficiaries under the policy. As far as setting up...
They got that message.
That's correct. There is no dispute that there is no communication where they say, I'm sorry, your designation of these individuals is not acceptable to us, nor would I submit that does that matter, because under the policy he had the right to designate it. They were not confused by his listing the McCrearys as guardians, which falls within how those proceeds would be paid.
And counsel, doesn't the policy itself provide default provisions? If there is no provision about how payment should be made, that there is a default provision for that?
Absolutely, Judge Rowe. The default provision, which started at the very application of the application for the insurance, is that it will be paid in a lump sum. If there's not a beneficiary designation, it would go to the estate, which is Mr. Beasley's client. But there's no genuine issue as to his designation of Madison Ann Todd and Heather Ashley Todd. And the trial court properly found that and did not, the court actually acknowledged that with regard to how it would be paid out, there may be disputed issues of fact. Now, those are actually moot at this point because they've been tendered, but that dispute has nothing to do and is separate and distinct from who the beneficiaries under the policy are.
Okay, so how do you see the role of his intent in all of this?
I do think that we do have the argument that he did everything he could do and demonstrate his intent, but frankly, this court should affirm the trial court's decision in that what was done has strictly complied with the policy, and his intent clearly reflects that he intended for his $2 to be the beneficiaries of the policy. But it isn't necessary to reach an issue of his intent at this stage because the record is clear from the undisputed facts that he in fact complied with the policy.
But to follow up on, appellant's counsel has suggested that one inference we can draw from Mr. Todd's failure to complete the guardianship and trustee request from Prudential is that he may have wished for his niece to remain a beneficiary of his greater estate planning scheme. What evidence in the record would support that?
Well,
if any.
And I heard Mr. Howell say that, and with all due respect, I don't recall any evidence in the record that reflects that the relationship between the niece or the greater estate planning scheme. There, and perhaps in his defense, as the court may know, there are several appeals and several cases that we've all been involved in with respect to this issue. But I don't believe that I don't think there's any evidence that in October of 1999, Mr. Todd's estate was all to go to his newly adopted daughter, Heather Ashley Todd, to the exclusion of anyone else. I don't believe that's in the record. If it's in the record, I would suggest that it reflects that it would have gone to his two daughters, not his niece. But I don't believe that's in the record. Either way.
So you're saying that the information did come to the company in a form that met their needs. They just had a substantive objection to the guardians that were named on the basis that this might embroil them in some litigation, which of course turns out to have been an accurate.
Well, I note that Prudential's not here arguing about whether the designation is good, bad, or ugly. The issues that Prudential raised had to do with how the funds would reach these two beneficiaries, Madison and Heather Todd. And so they had no substantive objection in the record or that I've seen that would suggest that they objected to these two daughters being the beneficiaries. And in fact, everything that they submitted reflects that. They had a substantive objection to how he wanted those proceeds paid to these two beneficiaries. And that correspondence, because he changes how much will be paid per month, to whom it will be paid, how long it has to be held until the daughters get the whole lump sum, none of which has to do with, and falls within separate provisions of the policy, as well as separate provisions of the form that they provided, none of that having to do with or affecting the change in the beneficiaries. Unless the court has any further questions, I would give the rest of my time to Mr. Beasley.
Thank you.
May it please the Court, Robert Beasley, firm of Lidvack, Beasley & Wilson, and I represent the estate of Calvin Todd. I want to just briefly touch on some issues that have been brought up by the panel. The trial court was asked to first interpret this section of the policy under a legal construction, under his right to interpret what the plain meaning is. The case law provides the court that's in the discretion of the court. Then the trial court was presented with 3 motions for summary judgment on a declaratory basis. Once you have interpreted the policy, determine if these facts effectively accomplish a compliance with the policy. Did Mr. Todd comply with the terms of the policy as written, not as to be interpreted or not with the words that the appellant seeks to add? The court interpreted the policy and said the policy requires 1 and 2. He then looked at the undisputed record of facts and determined that the October 18, 1999 change form accomplished that change. Then he looked at all of the other facts, the other correspondence, which included this intercourse about who gets paid and how they get paid. There's 2 questions, who gets paid and how they get paid. The who gets paid question is the beneficiaries. That was established in October of 1999. Judge Rowe pointed out in her question, all correspondence and all forms printed from the system of Prudential post-October of 99 designated Madison and Heather as the beneficiaries. The who gets paid was resolved. What was left is how does this get paid? And there was a default section in the policy. If this was unresolved, and if Calvin Todd just gave up because he could not convince Prudential to pay it under the settlement option, there were 5 of them. And then there was an alternative. If you don't like these 5, we can agree on a 6th. If he just gave up, then it defaults to lump sum, which is actually how it was paid in the end. So the how it gets paid portion was never resolved. And there may be questions of fact. And the trial judge says that in the last paragraph of his judgment. He says there may be issues about how it gets paid, but that is irrelevant to who gets paid. And the court was asked to narrowly answer that question after interpreting the policy. The issue here is that Ms. O'Brien, the niece of Mr. Todd, not Prudential, and to make this clear, Prudential did not take a position in this case as a matter of law. They were sued by O'Brien. Then they interpled the funds. The 2 Prudential representatives that were deposed did have some interaction with what Prudential does and what the process requires. And that's where all this language about processing comes from. That's where the appellant takes the opportunity to say, Judge, these words mean this set of items, this list of requirements. And the judge just said, no, I don't think these words mean what you think it means, Ms. O'Brien. And then, given these words and what I think they mean, which is my duty and my discretion as a trial judge, do these facts comply? And his answer was yes. I've looked at the words. I've looked at what happened. It was undisputed. The record was presented without any controversy as to question of authenticity, whether or not it was received. It was stipulated that it was received by the Home Office by Prudential. And so the very narrow requirements, strict construction requires strict construction as to what the words say, not what the parties now, subsequent to his death multiple years later, want the words to say. With that, if there are no questions, I thank you for your time.
Thank you.
I'd like to point out a few things that are extraordinarily important here. First of all, Prudential, after the 1999 request, sent a document that did not say, we've accepted your beneficiary change request, let's talk about settlement options. It said, we're unable to process your request.
All right, but the policy doesn't say we have to accept or approve. It says you must file with the Home Office in writing in a form that meets our needs.
Correct, Your Honor. And the testimony of Prudential and the records of Prudential and all of the correspondence show that it did not meet their needs for lots of reasons that I've already discussed here today. And all of the forms that came after the 99 request that opposing counsel relies upon to say that the beneficiary change had been accepted, it had not been. All of those were forms proposed by Prudential attempting to reflect what it saw as the intention of Mr. Todd.
But aren't you adding a new requirement that's talking about whether it has been accepted?
We are not adding a new requirement. We're asking that Prudential be allowed to enforce that the change request meet its needs. And it did not meet its needs because even the form, Your Honor, provides all of the blanks for all of the information that Mr. Todd should have provided. He just simply didn't provide it. Imagine the litigation that could ensue if Prudential is going to be required and other insurance companies are going to be required in a $10 million policy to accept the sort of beneficiary change request that was submitted in this case. They had never accepted it before. They made it possible for Mr. Todd to easily clarify this situation to meet Prudential's needs, which are important needs.
What do you attribute to the fact that they just then eventually went to the default option and paid lump sum to the two daughters?
They did not do that. In fact, they interpled in this action, and the testimony of all the corporate officers, even though they'd interpled and they're saying we don't take a position, when we went up to New Jersey and we deposed them, and their testimony is part of this record, they all said the change request wasn't effective. It failed for all of these reasons, and our motion for summary judgment below and our brief here points out all of the reasons that Prudential said it didn't meet their needs.
Why don't you briefly address the policy rationale under the strict compliance rule?
Right. Your Honor, strict compliance is meant to protect both beneficiaries, policyholders, and the insurance company. It's meant to avoid litigation. There needs to be certainty. And in those cases that opposing counsel has cited where there's been some departure from strict compliance, it's always been because the policyholder did everything that they knew to do and everything that they could do. And to not allow them to have their intent would be unjust. But in this case, 7 years elapsed. Prudential repeatedly corresponding with Mr. Todd. All he had to do was sign the form that he had signed to make my client the beneficiary years earlier. Mr. Todd was a sophisticated businessman. He was not an unsophisticated businessman, as the record shows. He had a $10 million life insurance policy. He knew what to do if he wanted to do it. He chose not to do it in this case, or he failed to do it in this case.
All right, I think we better leave it there.
Thank you.
Thank you very much. We will be in recess, and we're just barely awake, so we're going to have some coffee, and we invite you to join us